Good afternoon, everyone. Thank you for joining us for lunch. As you all know, we are here as part of the 17th Annual Civil Justice Symposium of the Law and Economics Center at Antonin Scalia Law School at George Mason University. And this is our keynote luncheon address. We are pleased to welcome and honored to welcome Richard Epstein, a longtime friend of the Law and Economics Center and someone who many of you, I'm sure, have heard speak about issues like he will be speaking about today on the past and future of the tort system. Richard Epstein is the inaugural Laurence Tisch Professor of Law at the New York University School of Law. He is the director of the Classical Liberal Institute there as well. He served as the Peter and Kirsten Bedford Senior Fellow at the Hoover Institution since 2000. He is concurrently the James Parker Hall Distinguished Professor of Law Emeritus and Senior Lecturer at the University of Chicago. He's a member of the American Academy of Arts and Sciences since 1985 and has been a Senior Fellow of the Center for Clinical Medical Ethics at the University of Chicago Division of Biological Sciences since 1983. He won the Bradley Prize in 2011. He's written tons of stuff, and he points out we should probably move on at this stage. But I mean, a long and illustrious career, and a long career of helping to inform the broader legal community and the community at large about legal issues and the intersection of law and policy. And we are delighted to have him here today, being the author of more than 15 books, including a torts treatise as well as a torts textbook, much of which is relevant to what we'll be discussing today. He provides regular commentary and analysis on in a number of different newspapers, his podcast and otherwise. He has a few opinions from time to time, and we're pleased that he's willing to share his deep insights and thoughts on the role of the tort system in today's society for the Law and Economics Center. So, Richard, I'm going to leave it to you.
Well, I appreciate the fact that Donald has now reminded me what the topic is about which I have to speak, because otherwise I might have talked about something else. But I have basically spent a very long time as a torts lawyer, and I have a very unconventional background, and I always say it because it's always true, is that the fact that my torts experience does not start in modern America, but goes back to Roman and to early English law, turns out to be the decisive advantage to understanding everything that has gone wrong with the tort system in the last 30 or 40 years. And the way in which we're going to talk about this today is with the transformation and expansion of the public nuisance doctrine that has been part of the Anglo-American system for a very long time, and which received its definitive explanation back in 1535 in a very simple case which involved the blocking of a public road. And what these learned judges had to do was to answer the following question. If you block a public road, which is common and open to all, or to take the other alternative, you manage to create some emissions into a public river or to a lake, which is open to all, how are you supposed to remedy the situations that are created with the damages that occur? Well, to take the road example, it turns out that there are 2.5 different kinds of difficulties. The first situation is if you block a road, it turns out that everybody who's on that highway is going to be delayed in getting from one place to another, and there is no one who could come back and say, the fact that you're late is not a harm to you because you weren't killed. It surely is a harm, but it's a small harm. It varies from individual to individual, depending on what the lateness does to you. But there are so many people and so many difficulties that the general rule that everybody developed in 1536 and which remains today is you need to get a remedy for these collective wrongs, but the transactions cost of individual suits relative to the gains that you get are so large that what you do is you give an administrative remedy, in this particular case before the court leet. What they will do is they will fine the defendant and use the money from the fines in order to correct the kind of underlying situation so as to put the system back into a sound position. But on the other hand, there are other people who may run into a barrier that was created by the obstacle or go off the road or find it difficult to get access from the road to their private property. And these people have some kind of special damages. So the solution that happened was there was a common wrong to everybody, but you are going to allow those individuals who had special damages from the situation to maintain a private right of action, so that in those cases where the injury costs are sufficiently great relative to the litigation costs, what you do is you go back to the same private law model that you ever had. And this distinction between the general and special damages continues to work to this day. And like every other distinction that you make, there are always going to be hard cases on the boundary line. And traditionally in these areas, it turns out that you have a house off the road and you lose access to it. Is that going to be enough of a damage to say that you're getting a special action, or is it not? And there's a lot of dispute on that issue, which tells us that we're now back in the usual happy place that we have, where there are hard cases in the middle and the easy cases on both sides. And so this is the model that we use. Now the question is, how does this model start to work when we come forward into more model time? Well, the answer is it works exactly the same way it did in 1536. The most important thing to sort of understand about the tort system is, since so much of it depends upon physical interactions of one kind or another, these sort of enduring physical relations mean that the legal transformations that you need in order to run the system as you move forward in time are mainly concerned with matters of evidence. They're not matters, for the most part, that require that you reconceptualize the basic area. And so to take a more modern version of this, and now we'll move to the other side, what you do is you have somebody who pollutes a public body of water. And at that particular point, this is a public nuisance. And the key to understanding the phrase public nuisance is to understand that it's just like a private nuisance insofar as it involves the emission of various kinds of substances, noises, pollutants of one kind or another. The private individuals will have their own remedy, but in the public, it turns out that the state, with respect to the water, is going to have to do something about it. But there are also going to be people who have some kind of special injury, and the same question arises before: who falls in what particular circumstances on this spectrum? And so the general rule with respect to pollutants is, if you're a fisherman and it turns out that your catch is going to be destroyed by the pollution that comes in there, you will usually be given a private right of action against a particular polluter. But if you're somebody who works in a restaurant and it turns out that the amount of catch that you can pay for from this particular source is going to be reduced by the pollutants, you're regarded as too far away. And so what happens is you don't get any particular remedy at all and have to be confronted with and comforted by the overall situation, in which the general reduction of pollution that takes place by the effective public remedies on fines and things of that sort, or injunctive relief, is going to protect you without giving the correct memory. This always leaves people somewhat happy. Everybody's hurt likes to get this sort of remedy. But when you start looking at some of these cases, like, for example, when there's massive pollution from oil wells and so forth, you realize that if you start taking into account the secondary and tertiary effects of this, the amount of private actions you take simply overwhelm the system relative to the deterrent effect that it has. So there's a kind of a very uneasy truce as to about how far out do you go when you deal with these questions, and there is nothing in the abstract that we can do that can displace judges who actually have to decide these cases on concrete grounds. So the question that you then have to ask is this is the scope of the tort law in the conventional situation. Is public nuisance law a problem that we seem to think has some serious kinds of difficulties associated with its operation? And I think the answer to that question, unfortunately, is yes, and that the explosion of public interest kind of litigation connection with the public nuisance doctrine has generally been most unfortunate because of a very simple proposition. It's simply too exotic relative to the framework that was first set out in 1536, and that what it does is, in effect, what it gets you around is all the limitations that are normally associated with private litigations in particular kinds of areas. And so what you then have to do is to kind of go through the list of cases, one kind or another, to see, in effect, what's happened. Well, let's just start with a small and non-controversial problem: climate change, right? You've all heard of that. Do you understand what's going on? Probably not, but you're not alone, because I'm not sure that I understand it either. But what happens is you then get the situation very clearly is, are you going to allow people to bring private rights of action with respect to the alleged damages that are caused by climate change? And we had this case about 11 years ago by Judge Ginsburg, I believe, not you, but the other lady. And what she had said was, this is such a complicated problem that we're going to have a federal preemption of any federal right of torts against these people who make directed emissions from these things, and that we're going to require the federal government to have a comprehensive program to deal with matters of climate change. And there are two problems here, one of which is settled by that kind of distinction, and the other one which is most decidedly not. The basic point is, if climate change is the kind of thing which is a genuine social difficulty, individual tort suits are simply impossible ways in which to try to deal with it. There are too many sources. I look around this room, and if I see 140 people in the room, I see 140 polluters, because each and every one of you exhales around 2 tons of carbon dioxide every year. And it's enough, if you take some people seriously on the accounting, to cause several $1,000s by exhalation of every individual person. And so what we now have the glorious situation in which everybody can sue everybody for these kinds of situations. Money changes hands, but no effective deterrence is going to take place, because none of you are going to stop breathing in order to avoid this particular kind of harm. So then what you want to do is you want to go after other kinds of polluters who are big. And it turns out it's just extremely difficult to know whom you put into this particular situation and why you put them in there. And so what happens is, the basic argument is, we cannot solve this through litigation. It's a good Coasian explanation. That's Ronald Coase, the father of transactions cost. The transactions cost is simply too high to allow the private rights of action to go. And so you now have to think of a direct system of regulation. And though the question of what kind of system of regulation you want to put into place, if you can't do private action, is a deeply controversial one, because of the second problem, which nobody likes to talk about in many cases, but which is very active in this area. How do we know what carbon dioxide does, and is it a global pollutant? Well, we know that there's something very weird about that entire question, because if you take this pollutant and root its level down to 0, which is what you normally like to do with pollutants, get rid of all the sulfur dioxide and nitrous oxide in the air, it has the inconvenient side effect of killing everybody on the face of the earth. Because you may want to call this a pollution, but given the very complicated cycle that you have between oxygen and carbon dioxide, if you drive the level so low with respect to emissions, you're going to kill all the plant life, which means you're going to kill every other form of life on the face of the earth either. So what you have to do is to decide that this is a pollution only if it turns out that it's in too much by way of the quantity. But even then, it turns out that there's 2 very difficult technical problems that you have to deal with. Carbon dioxide is a complicated substance, but it gets involved in multiple processes. And the single most powerful effect that it has when you're dealing with environmental issues, it has to do with photosynthesis, because it's a very simple process in terms of its ingredient, unlike global warming and with respect to various kinds of greenhouse gas effects. And it is known quite clearly that the more you have by way of photosynthesis under these circumstances, the more robust plant life will be. And so therefore, you try to shut this thing down in order to stop the greenhouse gas effect, you're going to shut down something else which has a uniformly public value. We know this for a very long time. A long time ago, I looked at some pictures in Scientific American of, this is when it was a real magazine, not the current version, in which they showed you pictures of plants that were done with low concentrations of oxygen and carbon dioxide and those with high, and you were much better off having high concentrations of carbon dioxide, which explains why various kinds of greenhouses and so forth always pump in extra carbon dioxide in order to increase the rate of plant growth. So it turns out that you really need this stuff. And then on the other side, how important it is with respect to greenhouse gases. And it turns out it's very difficult to figure out what those particular effects are, because there's so many other things, the cycle of the sun, El Nino and La Nina and all the rest of that, which influence the way in which these things start to work. And so you're left with the question is, well, how does carbon dioxide influence that? And it turns out there is a very complicated cycle. And what the cycle starts to say is, when it turns out that it's really hot, there's a high level of evaporation that starts to take place from bodies of water. And as that evaporation takes place, the cloud cover starts to increase, lowers the temperature, and lowers the level of emission. And then as slowly as it gets lower, then the clouds start to dissipate, and you go back again. So if you look at everything associated with global warming, it's all matters of cycles. It's never a question of simple linear equations. And therefore, trying to figure out how much something contributes to what is extremely difficult. Matters get even more difficult after the situation with the American Electric case, because plaintiffs' lawyers are extremely ingenious, and judges are often too accommodating with respect to their ingenuity. And so what you now start to do is you see a second level of actions taking place, not against the direct emitters of this stuff, but against the people who start to supply various things to various direct emitters, namely oil companies of one kind or another, who furnish all of the oil that used to run trucks and houses and generators and so forth. And you treat them as though they're the emitters. And this, too, again, starts to create some very great difficulty. So if you're the city of Boulder and you start to bring a suit, what you're going to say is every defect in the road system is attributed to the fact that you have too much carbon dioxide emitted from things that are sold by fossil fuels company, and you never ask whether or not temperature, neglected maintenance, and other sorts of things do it. So what happens in all of these cases, the moment you start to go to remote defendants, the causation on multiple grounds becomes much more difficult, and it's therefore extremely hard to figure out any connection between what's going on in the global warming space on the one hand with respect to the particular damages on the ground in a particular scale. And then if you're like me, you don't believe any of this stuff anyhow. I've looked at a lot of the studies, and if they're not done by plaintiffs' bar members, there are lots of independent scientists who have real doubts that you can attribute anything in terms of temperature increases to global warming and carbon dioxide. They have too many other mechanisms that explain what's going on, and the temperature movements are not clear enough to show any kind of clear causal connection between them. So what happens is, the public nuisance doctrine that we had when we started out with respect to somebody blocking a road so that somebody crashed into a ditch is now trying to expand so much further that not only does litigation not work, but it's probably also the case that regulation doesn't work unless you have a very precise knowledge of what's going to be happening to what and why. And I don't mean this as sort of general skepticism with respect to the Environmental Protection Agency. Quite the opposite. If you go back and you look at the level of traditional pollutants that you had in the air back in 1970, it's a very different world. I lived in Los Angeles at that time, and I knew that to go east to Santa Marina or Marina County, as opposed to the coast, a completely different transformation because you had some really toxic stuff that you couldn't breathe. You don't know when you have a high carbon dioxide day, but you certainly know when you have a high smog day, and your lungs start to ache. And so the advice that you give to somebody is take the low-hanging fruit, take the stuff that you know is truly dangerous, figure out how it is that you regulate that, and leave these other things where you're not even sure whether the sign is positive or negative to a later day, and then only move in specific circumstances where you're reasonably confident that you can attach some kind of response one way or another to the system. And so what happens is if you're trying to think of this stuff as a public nuisance, the evidence essentially starts to overwhelm you. The institutional framework is very uncertain. Multiple alternative causations that have nothing to do with carbon dioxide are very much in play. And so the view that I take of this subject is it's not that we don't want to have private litigation only. What we have to do is we have to be extremely careful on the way in which we deal with direct regulation. And just to give you one of the things that you have to worry about, a systematic effort to eliminate on public nuisance kinds of grounds the use of fossil fuels for various kinds of activities turns out to be a very dangerous situation, because what it does is it ignores the alternative hazards that take place when you start to use other kinds of stuff like wind and solar energy. And these things, too, have negative effects in the way in which they operate. The systems are extremely difficult to build and to maintain. The energy dissipation rates are extremely large. The collateral effects that you get from too much wind in the wrong places, being a low-level nuisance of the traditional vines, are very serious. The stuff with respect to solar energy and so forth has its own set of situations. They don't work when it's dark, and when it's light, you get too much energy. So starting to do this kind of situation, you get these incredible sense of cross subsidies where the government will buy energy from you when there's an ample supply at very high price, and then when you need it, so forth, they'll sell it to you at a very low price. And so what starts off as control with respect to externalities and pollution turns out to be an elaborate subsidy system which does credit to nobody. And this then requires you to say, whenever you start trying to deal with global regulation on any subject, it's not enough to simply talk about the harms of the situation that you're trying to control. It's also absolutely critical in a global sense to figure out the damages that are associated with the alternative technologies that you want to put into place, and that this requires a very complicated analysis, and almost always you can say with complete farm the same. You never want to put all of your resources in one technology, because diversification is, as everywhere else, is one of the best protections that you have against excessive regulation. And so if you trace back what goes on from the original case, you start to see, in fact, massive overregulation in the wrong direction. And you want to take a place where it's really dangerous, try looking at California, because you can trace where the damage starts to come in that system. And there's an ironclad rule. Anything which is owned by private property owners does not go up in flames. Anything which is owned by either the state or the federal government does go into flames. And you go there and you look from the air, you can see the differences. And so when you start to think about pollution, there's the following very danger that you have, is you don't tend to the most elementary rules for fire management that take place about getting rid of dead wood and making sure, in effect, that the publicly owned lands are properly maintained. I've done work with the Koch Foundation from time to time. They own Georgia Pacific. I do not think that there's been a single acre from that company which has ever gone up in flames. It's all on the other side, and it's because of the management issue. And so now you have a serious causation question. Who is doing what to whom that you have to be able to answer? And so just as a simple point on this, you start trying to take these models of public nuisances that work in very simple, contrived, very controlled situations, and then try to extend them more broadly. Everything that you're going to start to do is going to be subject to serious error costs. And how do we know that? Well, the learned governor of California, he basically regards global warming as an existential crisis. And then you turn around and you say, well, now have some serious shortage. He says, be careful not to drive your electric car. Why is that? Because it relies on a station which is powered by fossil fuels. And so if there's going to be a shortage that affects the market generally, it's going to affect the EV market every bit as well. So again, the lesson that you have to learn about this is the more complicated the system, the more cautious you have to be to make sure that you don't allow a doctrine like public nuisance to simply go and trust you into making wrong decisions in wrong areas, which can be avoided with a little bit more modesty and an understanding that using all of one technology is always going to push you to the brink. Better that you have a diversified pool in energy sources, just the way when you're investing in the stock market, you want to have a diversified pool in order to control risk. Well, you say, well, that's only one problem you have. There must be other areas in which it can be done particularly well. Well, let me mention to you a couple of other areas where it works very badly as well. There is the question about how you deal with lead. And it's a very actually optimistic story until you get to the last 5 or 10 years, because lead paint was absolutely the model form of paint that you had in the 1920s and 1930s. Everybody made it, everybody loved it, and in fact, as a form of paint, there's nothing that has been done since then in all the acrylics which is nearly as good as lead paint. But it turns out it has certain annoying side effects, right? If you start to do it, child development starts to get hurt. You have major forms of retardation that can start to happen. And the question is, as the knowledge gets broader about the specific risk, what are the kinds of things that you ought to do about it? And well, the first thing you do is you engage in incremental regulation, as I mentioned, and you stop using it on stuff on internal walls. Because if it starts to flake, the little kiddies are around, and they will start to put it into their mouths, and relatively small concentrations could have very devastating effects. And so you stop using it. You then have another very serious problem. What do you do with respect to transitions? And for those of you who have not followed this particular injury, which at one time I walked in fairly extensively, you put an acrylic paint on top of lead paint. It's more dangerous than covering lead paint with lead paint. Because what happens is the acrylic paint starts to bubble up, frame up, kind of, you see all sorts of irregularities, and the moment that that surface becomes irregular, what it does is it basically messes up the lead paint underneath it and releases into a serious situation, so you have very, very serious danger. Well, you have to deal with that, and maybe you just have to take out the lead paint to begin with in order to stop it. Also, you realize that there are very great dangers that are associated with lead paint, with lead when it starts to be put outside because kids can see it. It turns out there are very great dangers associated with lead in gasoline, so you take it out of it, and what happens is everything starts to go pretty well. And then you get the private rights of action. And it turns out, well, these things for the most part are not very well conceived. You've already reduced the concentrations far below, and I can still recall, and I checked with some of my own neurologists on this, what happens is the plaintiff bar takes over. It goes into public hearings. It announces that very low concentrations of lead, lower than you could experience typically, have very great dangers, and it uses that to fund private litigation off of public resource. And that's extremely dangerous when you've actually controlled the problem through direct regulation to make sure that you're going to try to find some other way to deal with it without direct regulation. And so you start seeing the lawsuits come up in places like California. And what they are essentially is they're misrepresentation cases that fail. And they are now called public nuisance cases that succeed. And so you can literally go back and see that there's somebody who in 1904 wrote a little memo and said, lead paint is the thing to use on your house wall. They don't even make any specific health claims. What they're doing is they're basically talking about the general wisdom of the time, which turns out ultimately to be incorrect. What happens is you take statements like this from 1904, and you don't require that there be proof of specific reliance by anybody on those statements when they use the paint or any misrepresentation. And you say, so long as you have put this stuff on the market and you've promoted it, you have now created a public nuisance. And the danger with respect to this is that if you start looking at product liability cases and misrepresentation cases, what you discover is there are very precise rules that have been developed over years which limit the ways in which these things can go. You have to show that there is a false statement, material, that has influenced people in the way in which they work. And in all of these cases, if you're trying to figure out the harms that take place, an advertisement in 1904 probably influenced 10 people, none of whom are alive today. And so now what you do is you lever all of that stuff into saying you're now under nationwide duty to clear up all lead in all houses in the United States owned by public government where there's lead in it after 1950. It turns out, as usual, the control of lead paint in particular residence is much more easily done by the landlord than it is by somebody who's long gone. But I could recall in the 1990s and so forth, defending cases that were done by very small companies a very long time ago. They get acquired by other companies, and then it turns out a huge company is going to have to bear liability for a tiny little company, which went out of business for actions that it had no control, which means that if you want to engage in the business of corporate acquisition, you are very, very well advised to make sure that you don't acquire any company which has any kind of remote possibility of torts, because if you do so, you're going to find yourself getting billions of dollars of liability associated with its operation. That is a common practice with respect to lead. It also happens with respect to asbestos and so forth. There is a danger of going after the wrong people for the wrong reason. And if you limit yourself to the kinds of things that I was talking about, these actions would just disappear, and you would concentrate, as you should always concentrate on these cases, on the party in possession of the particular facility to take the steps which are appropriate, if any steps are indeed appropriate, to minimize the particular harm. So you have to be very careful about those kinds of suits. And then there are the opioid suits, which are also commonly treated as if they are public nuisances. But you go back to 1536, and again, you start the summus premise. What you have to show is there's a danger to some common area, a common facility, from which there's special damages. And you can't figure out what the common element is with respect to opioids. Then what you try to do is to figure out who's responsible and for what. And it turns out, again, there's a very serious problem, even in individual cases, which is who made the particular opioids that in fact caused damage to what individuals. So if you're bringing an individual lawsuit, it's an absolute defense in these cases to say that the opioids that you got were manufactured in somebody's basement or cellar or garage using common elements that are freely available under technologies that are widely understood. The appropriate defense under these circumstances is to simply say you did not do it, and since you did not do it, you are not responsible for it. The information they got is from public sources. It'd be very difficult to say if you publish a manual which talks about the organization of opioids and so forth, that you should be responsible for everything that everybody else does. Then it turns out that there are cases that are involved where, in fact, what individuals do is they take some kind of medicine which contains opioids, and what they do is they mush it into pieces, turn it around one way or another, and they manage to overcome all of the defenses that were put into the drugs to make sure that they gave gradual releases, which were necessary for pain medication and its relief. And then you say, oh, they're now responsible. But if you go back, and I mentioned this at lunch, I think, to the good old case of Justice Traynor and his Scholar against Coca-Cola Company, he had a strict liability system, but he also had a modicum of sense. And what he said about this strict liability system, it only applied to those things which were in their original condition when they reached the consumer without intermediate alteration, and they were only put to a normal and proper use. And in every one of these cases, it turns out none of those conditions turn out to be satisfied. And so the question is why you would want to impose tort liability on individuals for doing the right thing to help patients, a clear benefit, because other people have managed to take and pervert. Well, you could say you could take better precautions against it. And I'm always a believer in precautions being taken. But if it turns out you tried to do this as a common law situation, the standard rule of litigation is, first of all, you figure out what level of precautions they took, multiply it by 2, and then announce that that's the standard of care that you have to put in these cases. So it doesn't matter what you do. What happens is we engineer a standard of care, which means that you've always taken 2 looks. So to give you an illustration, suppose we're talking about liability for a baseball field for balls that are hit out of a stadium. And a ball goes out of the stadium and hits somebody, and you say it's a common law situation. Well, if the ball went out at 25 feet, the wall has to be 30 feet. If the ball goes out at 45 feet, it has to be 50 feet. What you do is you reverse engineer. The reason why you want to have this done by ex-ante regulation is as follows. At that point, you don't know whether the ball is or is not going to go out, and you're going to get somebody to give an honest evaluation of what they think to be the proper height of a fence. If you make it too high, it turns out you kill views, it turns out it's very expensive, and it does very little good. If you make it exactly the right height, you're going to get the optimal results. You make it too low, you're not. Given the fact that you're behind a veil of ignorance in the legislative situation, you're much more likely to get an honest evaluation of this than you are if you do it in the judicial system, where there's always a plaintiff's lawyer who can basically say the following message with complete sincerity and total falsity. It's not, you don't say, I am from the government and I'm here to help you. That's another message, right? What you tell them is, you look at corporate greed and you have to send them a message to stop these kinds of behaviors. And if you start believing the message is only going to come through litigation, what you're doing is you're inviting essentially exaggeration and misinformation, and that's exactly what happens here. So if you wanted to do this through the usual system, there would be cases where you can find manufacturer liability, and these are the channel stuffing cases, where you sell too much stuff to a bunch of people and encourage them to give it out to people who don't need it, who then take it in the original form and make normal and proper use, but they're being maltreated. Those cases very much fit into the earlier paradigms, even if the other ones don't. Well, you then ask the question, what's the ratio as between the two kinds of cases? And I think it's probably very heavily favored for the defendant. So what you try to do then is to convert these into public nuisance cases, saying this is a hazard that affects everybody. And abstractly, it turns out that any time you have a product that fails, whether it be an opioid or penicillin and so forth, it's going to affect a lot of people. They're not public nuisance cases. And I've had with my friend Mario some effect in writing an amicus brief in the state of Oklahoma saying, you can't bring these as those kinds of cases. What you have to do is to go back and figure out whether or not you satisfy all the steps associated with a product liability litigation. And so at this point, what is public nuisance law? It's a very dangerous type of situation in which you tried to use a theory which had very powerful applications in certain limited cases, and you use it to say, now I don't have to prove all of the elements of a misrepresentation case. I don't have to prove all of the elements associated with the product liability cases. I don't have to prove all of the elements associated with the breach of statutory duty. I just go in there and I try to send people a message. Now, this is a very expensive message. And so I'm going to end on this particular note. I'm happy to take questions as long or as short as you want me to, which is that whenever you're thinking about any situation under uncertainty, what you have to do is take the oath that every member of the GMU Law and Economics Society takes. So you raise your right hand and you say, I hereby agree as a federal judge that when I'm dealing with regulatory schemes under conditions of uncertainty, I am worried about two kinds of error. One of them is over-enforcement and the other is under-enforcement. The general view that most people will take is under-enforcement is the thing that you really go after because it turns out it's a very serious stuff and you can understand it. Over-enforcement essentially doesn't have bodily victims that you can see, but what it does is it has victims who don't take particular kinds of treatments, don't get the advances of the most modern treatments with respect to medicine and surgery, because what has happened is the excessive regulation has driven those things off the market. And who cares about 1,000 statistical lives, all of whom are real people in the end, if what you can do is to protect the one individual you can identify by saying the rest of the world is just simply not relevant to these kinds of situations. It is the most dangerous mistake that you can possibly make in this business. Defense lawyers know how to deal with it, so-called. What they always do is they force you to go back to the ex-ante perspective to figure out the alternative harms that could arise out of the situation, try to concretize them and so forth. But it turns out doing this in the context of a litigation has the following very optimistic and pessimistic conclusion. If you are a good defense lawyer and you're dealing with a case that falls into this particular pattern, what will happen is you will win. I'm going to look at Miss Ween and so forth. You'll win 80% of the time, right? That's a pretty good number. Catastrophic number. Well, why is it catastrophic? Because you win 80% of the time, but you have to defend 100% of the time. You have to pay lawyers to defend it 100% of the time. Then it turns out that these claims are given broad public knowledge, so there's a reputational loss that somebody says, I'm bringing this particular suit against this deadly pharmaceutical product, and people will essentially stop taking it because they're afraid that it really is dangerous and then go to an inferior drug developed 50 or 60 years ago, which has a long time record of safety back in the good old days, but has been discontinued in medical practice for the most part because the professionals know that the newer drugs are by and large better. And how do we know that? Well, in some cases, if there's a very good generic drug like allopurinol and so forth, it's still on the market. Why? Because you can't think of anything that's going to do better, which is done perfectly. But if it turns out they're developing new drugs, and these drugs have a substantial price disadvantage relative to the generic, the only reason that they are going to be used by people is that there's some very strong belief that they're actually better in the performance than the cheaper drug that they're going to displace. And this is another message which is sacred to the GMU situation, which is that quality differences justify price divisions, and we don't want to simply have a uniform price for all prices, good or bad, because what it's going to do is completely distort the market. So what has happened is when you start talking about too much regulation. It's not only the lack of protection to people who have injuries that they can't bear, the whole reputational thing starts to talk about the industry. You know, I've worked for many years with the pharmaceutical company. You will not hear me say a single kind word about all the stuff with respect to the COVID vaccine, which I regard as a national travesty in one way or another. But with respect to traditional medications done in traditional fashion, this is my basic reaction. I'm going to end on this note, is that we at George Mason think about institutional arrangements in which we try to integrate both private lawsuits and public regulation into a coherent whole. Do I got that right, Donald? Well, I see I got it right. I'm a slow learner, but after 50-odd years in this business, I finally figured that out. So you're looking around and you're saying, okay, what's the situation? Well, with standard pharmaceuticals, where you don't have the government pumping propaganda out and so forth, what you want to do is to have a very strong preemption regime in which you try to get the right warnings ex ante, and you don't allow anybody to create ex post exceptions based on special circumstances, because the whole system will break up. The single greatest error that judges made, and I suspect that many of you are guilty of this, is you tend to think that balancing multi-factors shows your immense sophistication as compared to my utter naivete of thinking that simple rules for a complex world often work far better than those other things. And this is exactly a case. Every time you guys balance, you make mistakes, and there's nothing anybody can do to correct them. So what you have to do is to basically, when you take a preemption doctrine, take it very seriously, and then put all your energy into trying to figure out exactly what warnings you want to do, and then go to various people, patients, doctors, and so forth, to constantly overdone them. And I'm going to make you the following confident prediction. If you go to this system, the plaintiff's lawyers who tell you desperately how much they care to preserve the safety of the public at large will not make a single suggestion into any public discourse on areas where they cannot bring a private right of action after it's done. Rather, they'll do what they did in the lead cases, exaggerate the risk in order to promote the private rights of action. And then the second thing you want to do is to make sure that if you do warrant the drug, you get the drug that you were promised. So you take very hard steps against kinds of situations that involve contamination or misformulation of a product, and you put the lien on that. You don't have to worry about product liability. All you have to do is to be old enough to remember a bon vivant Vichyssoise. Any of you remember that? In the 50s, this was a very fashionable company, and it put out the best Vichyssoise in the world, and then there was a little fly in the ointment. One batch that they put out had tetanus in it. Well, what happened is they had to pay off 10 people or 20 people who died or were injured, and the company went out of business. You cannot resurrect the brand after you do that thing. So the other thing you want to do when you're a judge is to remember that the reputational constraints on firms that deviate from standard rules are more powerful than anything associated with litigation. So when you design your litigation, you are much more concerned with downstream abuse than you are with main company abuse. And if you look at the various cases in which it turns out that you have drug failures, if you have the right cameras in the right places, you can see some downstream pervert contaminating a different thing, a Tylenol bottle or something else, and it's downstream. There are ways that companies know how to check this. They never send all the product from one location to one location. They have all these funny little codes on the thing. I'm nerdy enough to actually read them to try to figure out what they say, but they're designed to make sure that you could isolate at which stage in the chain of distribution the error has been introduced into the system so as to counteract some wrong type of things. It's the kind of defensive protections that you take which are extremely valuable to consumers and to everybody else. So what is the message that I want to kind of leave with you? Is public nuisance law in its core mission is still essential for the way in which we run the world. Every single modern invention and extension that we've made off of that particular doctrine is wrong. The thing that's so important about it is they're all wrong in different ways and for different reasons. So you have to have a much more systematic and thorough examination of these particular things. And this is what I tell my students, and I tell my judges, that's all you, you cannot do serious, complex, modern litigation on this variety of topics unless you first learn the science of every particular area in which you have to do some litigation. If you don't know that, then they'll send you the wrong message instead of the right message. So essentially, the message with respect to traditional causes of action that survived for 500 years is full steam ahead. But with respect to the modern stuff that you see, which is dubious in so many different directions, it's hard to do it. The answer is be very slow and very cautious and admit new causes of action into the legal lexicon only after serious examination, reflection, to overcome major levels of doubt. Thank you.
Thank you very much, Richard. We have time for about 15 minutes of questions, and I want to pose one to you to start.
No, it's unfair. Go ahead.
You have given us a lesson of judicial modesty in many ways. Right?
And legislative modesty.
You used that word once in your talk. The modesty is about the capacity, I believe, and let me, correct me if I'm wrong, but you mean the modesty is about the capacity of the court system to actually resolve some of these problems, and therefore the avoidance of sort of the arrogance of a belief that the judicial system is capable of accomplishing some of these. If that's the case, I do think that message can sometimes get mixed up in terms of when judges have to figure out when to rely on scientific evidence and when to admit expert testimony. Because to the extent a judge is modest, they may believe that they don't have the ability to judge what should and should not come in, and therefore perhaps more comes in than should come in, which then, especially in a jury trial, means that they've not protected that second modesty role of ensuring that the courts don't get conscripted into being a vehicle for bad decision making per everything that you've taught us here. So, can you give us some of your thoughts on how do you work those two things together? The modesty in terms of the role of the judge and the role of a court, but also an aggressive gatekeeping function, if you believe there should be one, as to the admission of scientific evidence.
Well, the answer is it's very difficult to do so. And I think the first thing I would say is you're going to be much better as a judge if you're aware of the dangers that you face in both directions, so that you don't go into a trial with a forced sense that you know what's right, you're going to do it, you're going to do justice to this group and the other. What you have to do is to basically recognize that when you get novel causes of action, what you have to do is to decide them much more at the retail level than to decide them at the wholesale level. And it's also extremely important not just to rely upon the expert witnesses to testify, but to have you or your clerks go around and look at the extant literature to figure out what it is that's said by one way or another. Because it turns out that many times you get experts on two sides of an equation, and each of them have their own particular agenda, neither of which lines up with the social interest. And so basically having a situation in which you make your own independent assessment and then rely in part on these experts is, I think, an extremely important situation. It also, this is something else that I'm very keen with. I'm by training, a kind of a legal historian, because unlike most people, my legal education, first course I ever took in law school was Roman law. And this was at Oxford. And so I'm generally of the belief that these old guys were pretty smart. And so I try to extract what wisdom I can from them and go forward. So when I see somebody say that all this other stuff is garbage, silly, naive, and so forth, I just don't believe that. And I therefore basically give more weight to traditional doctrines that have been developed by jurists over centuries than I do to the wide-eyed speculation that sometimes happens with people who come to a case as a crusader. Well, that's the first. And the second thing, as I said, trying to figure out a system of causation. There is a tendency to say that if we're talking about global warming, we try to figure out about carbon dioxide. That's important. But alternative causes outside the system are every bit as important in understanding the way these things go. And so what you as a judge have to do is to take your expert testimony and then start to say to them, well, here's a case in which you're attributing this to global warming. Look at Maui. Can you tell me what the conditions were with respect to the discipline around the pipelines and the electrical facilities there over the grass that happened and how that might have related? And at this point, you have a very different trial because what you're going to do is you're going to have people come in and say they should have cut this particular grass because the following traditional hazards were very, very great. And if you think that, oh, this really doesn't matter, what I suggest you do is, particularly on fires and so forth, is you look at the global figures over 100 years. And they're really quite exceptional. There is no question, going to 1910, 1920, and so forth, the level of accidents that you had from fires was extraordinarily high. The acreage that was burned was very, very great. Generally speaking, they were in remote areas so that the amount of deaths that took place were relatively small. And then as you watch the curve take place, you would see that by 1950 or 1955 or 1960, the number of forest fires that you had went down by as much as 50%. And then as you start looking, all of a sudden they start creeping up again as you move to the 70s and to the 80s. So the hard question as judges that you have to ask, why the increase at this particular point in time? And it can't be because the technology is inferior to what it was in the earlier times, because the one thing we're reasonably confident of is, even though it may be misapplied or ignored, technological improvements are essentially always upward. They're not downward. You do not have somebody build a new car which says, I have this vast improvement that's taking place. I'm going to put carburetors back into engines when you've had fuel injection for 50 years. And then if you start to see that the technology has improved and that the outcomes have become inferior, what you have to assume is that management policies of one form or another have influenced the way in which the things have gone and sent them into the wrong direction. And at that point, you start looking to figure out what those particular things are that have made things go wrong. And what you will discover is that it's not technology that is the source of the problem. It's management systems that are put into place. And many years ago, I worked on a book which had to do with fire control of one kind or another. And it was pretty clear by the time you got done with all that stuff, you could understand what the kinds of philosophical situations were or premises that did it. So all of a sudden, instead of trying to minimize the amount of harm that comes from fires, you were told that it's improper for human beings to intervene into nature so as to alter the natural processes that govern everything. And that meant when you were running public national parks, you'd let the dead wood sit there, and then you'd let the leaves gather on the ground. And what it turned out is you created the perfect pyre so that a single spark could now ignite the entire area. After which, as the flames got hotter, it turns out it would take on more and more hardened targets of one sort or another until you had a very, very bad situation, so that in California, essentially the rule was, can we be sure that this fire does not cross the freeway? Because if it does, it's going to be more damage. But if it doesn't cross the freeway, it destroys monarch butterflies and everything else. And so what you have to do, in a sense, is to figure out that there are many, many situations where management techniques of an elementary nature are going to protect against various kinds of conditions that happen with a surprising level of frequency. And so that kind of stuff is what you need to do. So as defense lawyers, which I'm not always a defense lawyer. I mean, Jim Burnham's still a friend of mine, and so forth, is that what you have to do is you have to get the kind of full and comprehensive understanding about the way in which multiple systems interact in order to be an effective lawyer. And I want plaintiffs to do that as well, and judges to do it as well, because if the plaintiff's lawyers understand the strength on the other case, they're not going to be as willing to bring it, and judges are going to be more willing to throw them out on the ear if they don't. But remember, there are some cases in which it turns out things actually work the other way. So if you're taking product liability cases and so forth, there are certain kinds of drugs that have characteristic side effects which you can identify unmistakably, some of which they should have known about and some not. And if you find one of these kinds of industries which is uniquely associated with a given drug, all of a sudden your instincts on the case switch from the defendant's side to the plaintiff's side. But what you're trying to do is to get specific connections to be established when you work these cases. You're not trying to rely on the general proposition that all defendants whose net worth is more than $10,000 are evil in the way in which they look at this stuff. And I mean, that's, I've known Ralph Nader for a very long time, and I would call him a friend in some sense. But it was constantly the notion that Ralph had that you would always find some kind of corporate corruption behind every particular failure, which I think set people off on the wrong way. And I cannot tell you how dangerous it is if you brand safe and new products as unsafe because of the way in which it alters the rate of innovation and the rate of uptake of drugs that take from innovation. And that's part of the two kinds of error situation. And is there one golden bullet that happens? Well, listen to what I said. I said, in each of the cases, they're like Tolstoy's family. Good drugs are the same in all ways, but bad cases are different in every way, the way Tolstoy's families were in War and Peace. Well, you guys are not going to deal with the successes. You're going to deal with the family, for the failures. And so you have to understand that when you see something that goes wrong, there is no one single pattern that explains why or how it goes wrong. There are going to be multiple patterns that are going to have to take place, and you're going to have to ferret them out, which is why in the kinds of cases that I gave very different analyses of all the systems that I think have gone off the rail. So that is, I think, what the basic message is. There is no shortcut under this kind of business. I can try to tell you basically things to worry about, can give you cases in which bad things have started to happen, but there are going to be future cases that come up, and you're going to have to engineer them from the ground up. What you have to do is to have the right presuppositions that all that you can do at the general level. What you cannot do at the general level is to say, oh, here's a product that is yet to be invented. This is the way in which it's going to be perverted. Let's stop it. You just can't do that. So law professors, we have to be humble. Not really, but we should be, because the number of things that happen that we don't know is very large. And people ask me, well, how do you work when you consult with somebody? And well, I tell them the following truth. I'm looking at a room, and I'm looking at the panels that we saw today. And everybody on every one of those panels knows more about their subject than I know about their subject, because they've been in the trenches and have worked the details beforehand. So they're calling you because there's obviously something about their business model that doesn't seem to work in a particular case. And what you have to do is to first understand how the business works by listening to them. And what you tell them is, don't tell me what's relevant. Tell me everything. We'll figure out what's relevant later. And then what my job is to do is to figure out with these novel cases how to work. Sometimes it's catastrophic, but I can recall when I started to work for the American Insurance Association in 1976, they came up to me, and it turned out they had no idea what product liability law was about. Why was that? Because they never charged a separate premium for it. Why was that? Because the risk was so small that they threw it in with a bunch of other coverages. And so they started to tell me about what had happened. And then after a while, you could work with them to put the paper together. But as an academic, my first rule is customers and clients always talk first, and I listen first to try to get myself into an area of rough parity on the facts so that my comparative advantage, which is having looked at many, many different systems through many different lenses over many, many years, can be more effectively deployed. And I think that's the very important lesson that you have to learn and we have to work. The reason why you have cooperation, consultants, and litigation of this sort is because everybody brings something different to the table. And if we all have the same strengths or the same weaknesses, the gains from trade are very, very small. It's when we have complementary skills that they're the largest. And that's what I think you guys have to think of when you talk about, or as lawyers with your clients and so forth, or judges with your clerks and everybody else. Try to figure out where the synergies lie, and then try to figure out how you develop rules to deal with them. And it's the same process for a firm, for a litigation case, and it's also for a judge case. Figuring out how the different systems of social control interact and why they interact is the great question that you have to face. And the more systems we have, the more difficult it is for you to do your job, and the more difficult it is for me to do mine. Now, I'll take questions from somebody else, because you're an annoying man.
Yes, questions here.
Delayed absorption, as provided by OxyContin tablets, is believed to reduce the abuse liability of a drug.
Mm-hmm.
That is what Purdue Pharma told the FDA. That's what the FDA believed, even though they had zero studies to show that and a long history of abuse with MS Contin. Purdue Pharma argued preemption. Purdue Pharma lost in their public nuisance suit, which is how we finally found out that they were a bunch of liars. Now, it took another 20 years for them to go out of business.
You're a
But
plaintiff.
it turns out that those of us who did bring this public nuisance suit did find out this truth early on and tried to give it to other states so they could also get involved. because it was a public nuisance. They unleashed a drug that could be easily abused and affected a whole lot of communities in a very negative way. But people who thought they knew the science turned their heads and said, nope, we're going to let them do what they're going to do because, man, they're making a lot of money. And a lot of people defended them on both sides of the aisle, whether it be Eric Holder, whether it be Rudy Giuliani, whether it be Mary Jo White. They were all there to help them out and say, this is the fault of the abuser. What can we do? Now, public nuisance suits have a long history. Now, they almost went to somewhere in gun control, but as you know, that got stopped by federal legislation. They have a utility. When some people do things wrong and they have a whole lot of ability to protect themselves, ensconce themselves in lobbyists, in giving money to powerful people, someone has to do something. And that's what I like to think I get to do.
Well, let me tell you what I would think about you. I don't know all of the facts to be completely confident about this, but I do believe that if there is a situation in which there's fraud upon the FDA and the information that is presented, an exception to the preemption rule ought to allow you first to establish the fraud before you start going into this thing, before you start looking at individual cases. But what you said, in effect, deals with one part of the stream. It doesn't address in the slightest the people who create this stuff by themselves or by people who take the drug and then mince it into situations so as to avoid all the safeguards that are put in there. And I mean, if that's what you're saying, is that once you put the thing out on the market and anybody decides to abuse the particular product, the manufacturer is responsible is a mistake. Because the other thing which you didn't say, which is also, I think, part of the story, is what about the benefit side of this situation? So you start looking at people with acute chronic conditions and so forth, and the issue is what kind of treatments that you can give to them for palliation, which will increase quality of life and longevity of life and so forth, if you take OxyContin off the table. And so what I would want you to say before I'm completely persuaded is tell me what the substitutes are and how they work and why they're not going to be subject to the same kinds of critiques. The other thing I would want to say, just listening to what you say, is there's an old Roman maxim called audi alterum partem. Hear the other side. So I'm not going to make any judgment with respect to these things unless I hear from the manufacturer of those drugs exactly how they would want to refute your kind of charges. And so what's always dangerous about these kinds of speeches is that they are presented by interested parties as though there's certain questions of fact, where in fact there are interested parties on the other side. And I think that's the importance of having both parties. What I think is completely wrong with respect to the FDA is that its receptiveness of taking in new information turns out to be extremely slow, and that means that companies that want to correct things cannot do that. And I think Ms. Wien could try to document. What? Well, it's more complicated than that, right, Ms. Wien? I mean, you just can't go in and change labels. It's much more complicated than that in terms of what's going on. So I'm going to again give you the Epstein other rule, which is, okay, I believe that kinds of things like this happen, but it's so complicated, I want to hear both sides before I make a final and definitive judgment. And what you want me to do up here is to give a summary judgment to your particular indictment without hearing for the other side. I don't think that that's a wise thing to do. And as I've mentioned to you, there were some cases where I think it's certainly clear that they did misbehavior. The stuffing cases, I think, are serious ones. But the alteration cases, I think, go in the opposite direction. And then, you know, when you start looking at the public nuisance cases, you have to figure out how many of them are products that were supplied by the manufacturer and how many of those which were generated in different ways before you figure out what the total level of damage is. So the question I'm going to ask to you is, if some guy goes into his laboratory and makes all of this stuff and feeds it to himself and his friends, knowing of the risk but hoping for the benefit, should you sue the established manufacturers for a product that is made by somebody else when it never went through the FDA for any kind of approval? And your answer is yes, then God help us all. But if your answer is no, then it turns out we have an interesting discussion on how we figure out what the relative ratio is between these two cases. And the answer here is not a private nuisance suit. It's the question of whether there should be fines against companies who play fast and loose with the rules, for which I'm strongly in favor. And I'm going to say something else which may be horrifying. If you're a reputable drug manufacturer, one of the things you want most is fines against your disreputable competitors, right? Because otherwise, it turns out if you don't get the fines against them, what you're going to see is that bad companies can advertise their products on a parity with the good companies, when the whole point of warranties and regulation is to allow people to make quality differentiations, sometimes good versus better, sometimes good versus bad. And I'm all in favor of that kind of stuff. I didn't come up here and say, don't do any form of regulation. What I came up is to say was, in the areas that I know something about, there are a lot more kinks in the system than you might otherwise mention. And I could also tell you the whole question about, for example, the use of generic drugs in various markets is so complicated in terms of the way in which it ought to be done, that when you start seeing individual cases, you really have to look very closely at what is going to be borrowed, what is going to be shared, what is going to be proprietary, what is not, before you can even figure out whether these things get on the market. So I'm going to again repeat the same message. A little bit of caution is much better than a lot of denunciation.
On that, we are at time. So thank you, Richard.
You're welcome.
I wish we could spend more time with questions for Richard Epstein. He sure can take a few more. I know he needs to leave pretty soon after this.
No, I'll sit at my table.
But if you do have questions, feel free to come on up. But please be in the auditorium again at 1 o'clock. So, sorry, 2 o'clock. So we will reconvene in about 12 minutes.